Hi there. My name is Matthew Rendley. I'm a partner in the estate litigation group at Loopster Nixon, and I'm here.
I'm Eric Hofstein. I'm a litigation partner at Fogler Rubinoff.
And we are here to discuss, as part of the Amicus Curiae program, a module on explaining orders giving directions and scheduling appointments versus hearing appointments. So to start us off, Eric, why don't you just give us a bit of an explanation on what is the difference between a scheduling appointment, colloquially at 9:30, versus a hearing appointment, a 10 a.m. appointment.
So there are typically two types of hearings that you most commonly deal with on the Toronto Estates list. And one is referred to as a scheduling appointment, and the other one is referred to as a hearing appointment or a hearing matter. And scheduling appointments are normally booked for 10 minutes. The court will allow, I think, you to book 15 or 20 minutes, and they're typically for dealing with matters that are on consent, or if they're not on consent, that can be easily dealt with within that time. So simple, discrete questions where counsel can make their submissions in a very short time and a judge can come to an easy decision, typically concerning procedural matters. Those appointments are called 9:30 appointments because they are typically scheduled at 9:30, although these days the time can happen anywhere along the range of 9:30, 10:15, even I think I've seen bookings up to 10:30, but they are for simple procedural matters and consent matters. A hearing matter is what you would normally know as a motion, as a properly scheduled civil motion. And those happen, again, typically at 10 o'clock or possibly later whenever the court can schedule you in. And those are for matters where there will be a full record before the court, typically where the parties will need time to make their arguments, and where matters are typically not on consent or not simple matters to adjudicate on the spot, where it'll take more time for the judge to hear submissions from the parties before coming to a decision. And to schedule those matters, the starting point is to write to the Toronto Estates list. The email address can be found in the relevant practice direction, and the court registrar will typically ask you. They'll want to know how much time you need, whether you're asking for a 9:30 appointment or a hearing appointment. Whether there are any unrepresented parties, that's always a useful thing to explain to the booking, to the trial coordinator or the registrar, whoever's booking the appointment, and at some point you will need to take those dates that the court clerk gives you and inform the other parties, if you're into the proceeding, about what those dates are, and pick one of those dates. You'll have to fill out a form, which you will then email back to that same staff person to book the date. Keep in mind that dates have to be confirmed 5 days before. I think actually now it's 7 days before, and the court will also want you to, in the form, give some additional information about the name of the case and what the purpose of the hearing is. The form is also available on the court's website and should be emailed as part of the same email chain that you've started with the court. The court staff often want to see the entire email chain relating to a particular case. So you would, once you've requested a date, once you've booked the date, sent in the form, and are confirming the motion, it should be part of the same email chain so the court staff can go back and see what's happened. So Matthew, why don't we turn now to what the actual hearings are like, and in particular, motions for directions, which really form the backbone of estate litigation on the Toronto Estates list. Tell us a little bit about how motions for directions work.
Absolutely. So a motion for direction is, as it sounds, you're going before the court to ask for particular relief in the form of a direction to move your matter forwards so that it can get to a trial. So the directions that you're going to need are either for production orders, you might need particular injunctive relief, you might need orders validating service. There's a whole host of orders that are either procedural or substantive, depending on the substance of your application, for which you're going to bring a motion for directions. And so I know I just used a bit of a reverse of terms in explaining that a motion for directions can come in an application, but that is in fact the case. There are different rules, and pay close attention to the rules of civil procedure, and if you're moving under Rule 74 or Rule 75, which type of avenue by which you will be moving before the court. If you're in a probate file, then you'll be bringing a motion for directions under Rule 74 or 75 with respect to getting triable issues for proving a will. If you're in an application under Rule 14 and 75, you're going to bring an application, and in there, your notice of application, seek the orders you want, and then take bites of the cherry as you go back with your motions for directions as the case evolves. And so the different types of directions that I was speaking to pertaining to either disclosure or preservation or injunctions or service, setting down your triable issues when you're ready, those are very important to focus on and to make sure that your orders are properly drafted. And to assist the court, there has been model orders prepared and reviewed by the court and the Estates List User Committee and made available to the public as well as counsel for use on the estates list. And best practice in reviewing those model orders is to blackline what you are or are not going to be using from the precedent forms. If you're going to be modifying language because not every case fits in the same box, you be sure to blackline, provide the copy to counsel, seek consent, have a consent form if the matter is going on consent, signed and filed and then uploaded to case lines. And if the matter is not going on consent, have your black line and clean version ready to go, uploaded to case lines and appended to your confirmation form as best practice, which the timing for filing is in the practice directions. If you miss the time for confirming your motion for directions, you risk having your matter struck off the list for the day. So be very careful in making sure that you have confirmed your hearing appointment or your scheduling appointment for that matter. It's the same process, same form, different parts of the form are filled out to identify the nature of the day's proceeding.
And if you do have a dispute about those individual aspects of the order giving directions, I've certainly heard some people, and I'll ask you if you agree with this practice. Some people, what they'll do is they'll have one version of the draft order giving directions, which one party prepares, and have the other version of the draft order giving directions, which the other side is prepared, and you can highlight which paragraphs are in dispute and highlight which paragraphs depart from the model order, just to make it clear to the judge what issue needs to be dealt with on that motion, on that hearing, whether it's a scheduling appointment or a full motion, and highlight where the argument lies. And is that something that you've seen as well? Is that something you would do?
Yeah, that's absolutely best practice in my books, particularly as amicus curiae, because your role is to assist the court. And so in assisting the court by explaining where the parties have essentially come to a meeting of the minds or an agreement and to where they diverge, will be the most effective and efficient use of a court's time. And keep in mind that when you are asking the court for time in your scheduling request form, to make sure you are not over or understating how much time is needed based on the issues in dispute, because the court's time is very in demand, and as an officer of the court, it's a duty, whether amicus curiae or acting as counsel, regardless, to make sure that you are respecting the court's time and providing the judges with as much opportunity to resolve the matter in one go for the economies of justice purposes.
So let me ask you about just digging into these orders for directions and what sorts of things you can ask for. And one of the most popular things is third-party production. So let me ask you just to talk for a bit about what sort of third-party production you typically find in estate litigation matters. What are you looking for from third parties?
So depending on the nature of the dispute, if it's a will challenge, you're going to be seeking most appropriately medical records, solicitor's records. You're going to ask for financial records as well, in addition to orders for examinations of non-party witnesses. But the main thrust, for the most part, will be the solicitors and the medical records. If it's a guardianship application, again, medical records are going to be paramount. If it's an issue on a passing of accounts application, financial disclosure. If it's an issue with respect to challenge of a inter vivos transfer, that again leads itself to solicitor's records and potentially accounting records and lawyer's records, or real estate files from a real estate agent or a brokerage. There are a myriad of third-party records that are salient to the particular challenge before the court. But notice the use of the terminology third-party records, meaning that they're in the control of an individual who's not a party to the proceeding. So for the most part, those individuals are not given an opportunity to review and respond to the order requiring their production. That's typically because it's not practicable in the circumstances to be seeking the consent on an order giving directions from CRA before you show up at a contested hearing. That said, there are circumstances in which you can seek the consent of an individual, whether it be a family doctor or a lawyer, and then you're going to want the consent to the form and content of the order as it pertains to the release of records and waiver of privilege and confidentiality by counsel for Law Pro. If there's an accountant, they might have their own body that wants to review and comment on the order. If it's from a financial institution or the files of an investment advisor, they may want to have a review and comment on the order. That's different than asking for all the documents at large from RBC. So you have to be very mindful of the circumstances, the extent of the obligation on the third party, and be very aware that if that third party feels that they are obligated to comply with an order which they don't agree with, they have the opportunity to challenge that and seek to vary it under the rules of civil procedure. So if you can't be going on, and this is not for me to say you cannot, but you will be mindful of when judges hear your request in court and remind you these applications are not fishing expeditions. There needs to be relevancy and materiality to the documents sought based on the claim.
Now, some of the documents that you've mentioned, it brings up an obvious question of how you can even get access to these documents. You've mentioned lawyers' files, and lawyers' files, I would imagine, are protected by solicitor-client privilege, usually with either a deceased person or who can no longer consent to the disclosure, or with a living person who may not want to consent to the waiver of privilege. You might also have, you mentioned financial records, medical records. These are maybe not protected by privilege, but there can be rules of confidentiality that apply. So how do you deal with those questions of privilege and confidentiality when you're trying to get these third-party records?
It's a very important question, and the model orders have very good language in them allowing for the waiver of confidentiality under the relevant statutes in Ontario and the regulations, as well as the waiver of privilege, which we know is a common law protection of privacy. So the language which goes into the order giving directions to waive the privilege and the confidentiality needs to be appropriate for the circumstances. It cannot be too overbroad. And again, I remind you listening to review the model orders and tailor them with a black line as you see appropriate for the circumstances, and get approval, particularly from solicitors' records, where possible, from law pro counsel appointed for the lawyer whose file is being sought released.
Now, you mentioned dealing with these third parties directly in formulating your request. One question that I'm sure would be on people's minds is, do you have to serve any third party from whom you want to get records? So for example, if you're bringing a motion for directions, do you need to serve the financial institutions, all of the medical personnel, all of the lawyers who may have files that you're trying to get access to? Do you need to serve all of them with that motion for directions?
Technically, I would say yes. I would say if you have a third party on whom you're seeking an obligation to comply with under an order, they need the opportunity to see what they are required to comply with, and have an opportunity to comment on that, either to consent or oppose it in court. That said, as we've discussed, there are circumstances where it is not practicable in the circumstances, and judges, of course, have broad inherent jurisdiction in order to adjudicate and move forward in application. They have the ability to control the process, and so it may be in a judge's purview that consent to the order by the third party is too remote to obtain and too impractical, and instead it may be an issue of, they could have X amount of days in the order to move, to set it aside or vary it based on their review of it and objection on compliance upon being served after it's been made. There could also be, a circumstance where the court says to the moving party, there was an opportunity for you to obtain consent. You didn't take it, and so this relief is not being granted. Although there is inherent jurisdiction, there's also a process which requires knowledge and due service. So it's a balancing act. It comes down, in my view, to relevance and circumstance and reliability, and have your affidavits of service prepared and filed, and make sure you can demonstrate that all of the I's were dotted and T's were crossed as best as possible in the circumstances to obtain the relief you're seeking. So, Eric, once we've gotten the orders and we now have the evidence we need to move the matter forward, in order to now determine what supporting facts are going to be put forward ultimately at the hearing of an application or on a trial of an issue, What about mediation beforehand? On the Toronto Estates list do moving parties need to deal with mediation before being certified at a pretrial?
Well, that's exactly the issue, is that you can't get to a final adjudication of the issues on the Toronto Estates list without first attending mediation. The courts encourage settlement in all civil proceedings, and that's certainly no exception on the estates list. In fact, the rules provide for mandatory mediation on the Toronto Estates list, as well as in some other jurisdictions in Ontario. On the Toronto Estates list, you have to go to mediation at some point before having a final hearing on the merits. And when you have that mediation is up to the parties. In some cases, it'll be appropriate to hold mediation very early in the proceeding. Some examples of when that might apply would be if all the facts or most of the material facts are known to the parties. If discovery isn't needed, it's just a question of the legal issues of working through the parties' interests, then it might be appropriate to hold a mediation early in the proceeding before incurring the cost of cross-examinations, maybe of additional discovery, of additional proceedings and motions. And in other cases, it might be more appropriate to hold a mediation after the discovery process has taken place, especially if there's a lot of gap in the knowledge of the parties that would be required in order to work through a settlement. So for example, if a party is sitting there saying, look, the whole reason that I've started this proceeding is in order to get information about, for example, how an estate was administered, or whether a person had capacity at a relevant time, for example, in a will challenge. And if they can't if there's no point in sitting down and trying to hammer out a settlement without that information, then it may be more appropriate to wait until that discovery process, whether it's documentary discovery or oral discovery, until that discovery process has taken place. And that might be the time to sit down and then try to work out a settlement. So it's very case specific, and the people involved really have to turn their minds to when it would be appropriate, when the parties are ready to sit down and talk mediation. That's not necessarily to say that the parties want to settle and have to want to settle before going to mediation, because at least in my experience, parties often don't want to settle, they want to litigate, and it's only once they sit down at mediation and start putting their heads together that a settlement can really be worked out. So it's really up to the parties to think not so much about when they want to settle, but rather when they're ready to sit down and have that conversation, when they have the knowledge, the information that they need to have a productive mediation.
So Eric, on the issue of mediation, when you're preparing your order giving directions, how specific do you tend to get in setting out, the issues for mediation, the place of the mediation, the mediator, the costs? Maybe walk the audience through how you would formulate an order for mediation.
And it's interesting because it draws directly from the model orders. In many of the model orders, I think in all of them, there are provisions specifically dealing with mandatory mediation, because it's mandatory on the Toronto Estates list. And the typical setup for a mediation in an order for directions will include what the issues are, and that's typically spelled out in the pleadings, when you are dealing with proceedings such as a will challenge or a passing of accounts. The pleadings will consist of either the notice of application or the notice of objection in the case of a will challenge, or a notice of objection in the case of a passing of accounts. And the order requiring mediation will typically set out specifically that the issues to be mediated are those that have been raised in the proceeding. The parties are free to add to that. If there are other issues that haven't been raised, you might consider asking a judge to provide for those additional issues to be mediated as well. That would normally require consent of the parties to do, especially if it's an issue that hasn't been raised in the proceeding. But there's nothing preventing the parties from mediating those issues. You would also want to deal with who pays the costs of the mediation. In some cases, it may be appropriate for the parties to share the costs of the mediation themselves. In some cases, it may be appropriate for an estate to pay the costs of the mediation. In all cases, the cost of the mediation, it may be most appropriate to have those costs ordered to be paid by one party or the other, or by the estate, or shared only at first instance, and leave open the ability to all the parties to seek their costs from the other side or from the estate on a final determination of the issues. So you might want to have a caveat in the order that says that the estate, for example, might pay the costs of the mediation at first instance, but it's open to the parties to make submissions for costs to be paid by either one or the other of them on the final hearing of the case. And that brings us to another aspect of the procedure, which is, what do you do after the mediation? If the mediation is unsuccessful, what's the next step? And it raises a difficult question to answer. It's one that I certainly struggle with, which is whether to proceed by way of an application, whether to continue typically as an application, or whether to convert your application to a trial of issues. It's a difficult question. It really comes down to each individual case. And some of the considerations that you might want to think about are if there are issues of credibility that might require viva voce evidence, that might require a judge to see a witness and to hear directly from a witness before making a determination on a case, then this may be a more appropriate case for a trial of the issues. And just to back up for a moment, the rules of civil procedure provide for converting an application into a trial of issues. And that can be done through a motion for directions. One of the other considerations that you might think about is whether the evidence is largely known or unknown. If you need a fact-finding exercise, then it may be appropriate to have a trial of issues. But if the facts are largely known and it's really a question of legal argument, then it may be best to keep your proceeding as an application, which tends to be a bit more efficient through the court system. You can simply bring on your matter for a hearing rather than go through some of the interlocutory steps to get to a trial. And so that's a consideration that counsel will have to turn their minds to in every case, whether it's appropriate to continue as an application or whether it's appropriate to convert the proceeding to a trial. So let me turn now as a sort of a final question for you, Matthew, and that is, and you touched on this earlier, but it concerns fishing expeditions. And we've all had situations where clients will come to us and say, look, I know that there are risks of going to litigation. I know there are cost consequences if I lose the case, but I don't have the information that I need in order to decide whether I have a strong enough case to bring a will challenge or to challenge a passing of accounts or to bring a guardianship application. I want to get some documents first. I want to see what's out there. I want to see whether maybe my mom didn't know what she was talking about when she met with her lawyer to give will instructions for this will that I'd like to challenge. How do you go about getting information before commencing a proceeding, and what are the limits that a court will put on what might otherwise be a fishing expedition?
Well, this is a loaded and complicated question, which I appreciate. And
I send it to you.
I think you've got to take a 30,000-foot view at the beginning and decide what type of evidence you need in order to support your cause of action. And from there, you then decide what avenue you are going to bring your proceeding. Are you going to bring it as an action, or are you going to bring it as an application? And you have to be mindful of the rules of civil procedure, which say that every proceeding commenced in Ontario is to be commenced by way of an action unless a statute says otherwise. So that's why you have to think beforehand and assess what is your cause of action and what evidence do you need to support it? And is there a statute which directs you to pursue the relief you need by way of application? And if that's the case, then you need to be mindful that there are minimal evidentiary thresholds that will apply in certain circumstances because there are presumptions of capacity. There are, let's say, legal thresholds that prevent parties from coming to court on an application to seek evidence in order to then manufacture a claim. If you're bringing your application by way of action, then you of course have all the discovery rights that follow an action, but your claim is subject to being struck under the rules. So although an application is as well, there are different considerations for striking an action that is unsubstantiated or doesn't properly plead a cause on its face, as opposed to striking an application for not meeting a minimal evidentiary threshold and not being able to be pursued because the individual is simply on a fishing expedition in order to then manufacture a case go forward. So you want to be very mindful of the procedure based on the type of claim and then determined by what type of evidence you need. And in seeking orders for disclosure in an application, you need to justify the relevance of the information to the claim and explain that there is reason and need that would call into question whatever presumption or legal onus that stands in your way of your application. And you need to demonstrate that that evidence is necessary and has some expectation, not necessarily an air of reality as is put in criminal proceedings, but there needs to be some substantiation that there is a connection and a reliability on that evidence to support your cause of action, whether it be because of a suspicious circumstance in the case of a will challenge or a challenge to an inter vivos transaction, or whether it be because you're seeking leave to compel an attorney for property to pass their accounts and you need to demonstrate that there's a need to look further behind the curtain to then seek the court's leave to require that attorney to pass accounts if you're not the individual with a statutory right to compel it, or if you are seeking a guardianship application and it's opposed and there is need to demonstrate to the court that the individual requires some assistance and that there's a power of attorney document that stands in place that may be subject to challenge because there is scrutiny on the presumption of validity based on the vulnerable, in-questioned grantor.
So if I understand what you're saying, you can commence an application, as you said, which is the court proceeding that you're going to start with. You can commence an application for directions by which you can ask for disclosure of certain information, but you have to, in that application, provide sufficient evidence to persuade a judge that you need to get this information before commencing whatever the ultimate proceeding would be. So if you're going to demand a passing of accounts, or if you're going to challenge a will or bring a guardianship application, for example, if you suspect that the attorney for property is mismanaging an incapable person's assets, but you don't know if they are, you may have the ability to bring an application for directions seeking disclosure of some limited financial records in order to assess whether there's been any wrongdoing. But you'd have to at least provide the judge with some evidence that suggests that there has been wrongdoing. For example, the person, has been isolated from their family for a long time, or family has been denied access, or that the person has been living very comfortably for a long time and now is living in squalor, and there's no logical reason for that to happen, and so there's some suspicion that something is going wrong, and you don't know what, but there's enough of a question, enough of a suspicion that warrants at least some limited discovery before commencing a full-out application, and that's really where the line might be drawn between a proper litigation discovery and what would be called a fishing expedition, which the courts do not generally condone.
Yeah, I would definitely concur with that, and you have to be very on top of all the facts and understand the law you're trying to rely on, and understand what evidence you need in order to support your relief, and determine under what legislation, if by statute, you're going to need to bring your application. And so I think in consideration of all of those factors, you are then primed to go out and obtain your order giving directions, either at a scheduling appointment on consent or at a 10 a.m. hearing at a contested motion, and be sure to file your FACTA in accordance with the rules. And if cross-examinations need to take place first, that needs to be conducted. If not agreeable, prior order giving directions can be taken out for that litigation timetable. And that is how you move the matter forwards, ultimately to the mediation, and then to a pretrial and potentially to an application hearing or a hearing of an issue by way of a trial. So
Very good.
Thank you very much for listening. We hope this was informative, and we appreciate your participation in this program.